Okay, guys, welcome back to another video with Pratham Test Prep. This is your host Sanjeev Bhatia again, and we are back with a new video regarding your legal affairs for CLAT and AILET. So, all of you who are preparing for CLAT and AILET are completely aware that your exams are happening in the month of December. So, the dates for AILET and the forms have been released. So, the exam is on 11th of December of 2022. So all the people who are aspiring to go to the National Law University in Delhi, then you have to write the AILET exam. So do make sure that you are filling up the forms on the right time and picking up your centers as soon as possible. Right, so welcome back to a new video. So if you are not a part of our Telegram channel, do make sure that you subscribe to our Telegram channel under the name of CLAT@Pratham. And also don't forget to hit on the like, share, and subscribe button. And most importantly, don't forget to hit on the bell icon for all these regular updates. So in the last previous week, there are a lot of things that have happened. And today we are discussing few of those events that have happened in the previous weeks, and also something that you need to remember for your exams. Now, so the first news and also the most elongated news that we will discuss today is that the Supreme Court is planning to have two constitutional bench. So, right, Mr. U. Lalit, Justice U. Lalit has become the Chief Justice of India. So, he is the person who's trying to have these two constitutional benches, which will start sitting from 30th of August, wherein four matters will be listed before each bench, right? So, they are starting a new bench. Four pending matters are before each of the two benches. The Supreme Court issues a notice on 29th of August to have the two constitutional benches sitting, right? So the first bench will consist of Justice Indu U. Lalit and Justice Dinesh Maheshwari, S. Ravindra Bhatt, Bela M. Trivedi, and also J.B. Pardiwala. So these are the people who will be a part of the first bench, and they will be taking in a lot of cases that are in front of them. There was a list of 25 cases, but I've picked a few for you to understand what are the matters that are in front of the Supreme Court of India under these benches itself. So, the first case that comes up is that the state of Andhra Pradesh and others versus B. Archana Reddy and others with 18 linked members. Now, this was the case which was regarding the SPGC quota for the Muslim in Andhra Pradesh, right? So, socially and economically backward classes quota is the full form of SEBC. Now, the questions that were arising in this case was whether Muslims are, as a community, may be declared socially and economically backward for the functioning of Article 15 and 16 of the Constitution of India. And the second point that was the point of discussion was whether there have been applicable and clinical fabrics earlier than the commissions to return back to an end that Muslims in Andhra Pradesh were as a community backward and socially, educationally backwards, right? So now, what was being said in the judgment of this case, and they will be discussing in further, but earlier in Archana Reddy versus State of Andhra Pradesh, the AP reservation of seats in educational institution and appointments or posts in public services beneath the State to Muslim Network Ordinances of 2005 turned it into that the whole Muslim populace beside the state cannot be declared as a socially and economically backward class. Right now, the judgment of the court laid down that there may be no prohibition to claim Muslims as a network socially and economically backward for the functions of the article. Now, 15.4 and 16.4 of the Charter of India furnish that they fulfill to take the look at social backwardness as said within the judgment. Now, going through what's said within the judgment, the bulk of judgment held that the whole Muslim network in Andhra Pradesh isn't a homogeneous magnificent, and also there are numerous groups and lessons amongst them. So the court approvingly quoted the finding of a case called N.K. Murlidhar Rao. Now, so exactly you can understand from this that they will be discussing the reservation that should be given under the SBC quota for Muslims in Andhra Pradesh. That is the main context of this case, and these constitutional benches will be discussing on them. Now, coming to the next part is the second case, that is the Shiromani Gurdwara case, that is the SGPC. Now, so the Shiromani Gurdwara Prabhakar Committee versus Shell, Mittal and others. Now the matter relates to attracting a field with the aid of using Shiromani Gurdwara Prabhakar Committee had the selection of Punjab and Haryana excessive courtroom, referring that to reservations for Sikh University College students in her SGPC controlled institute below minority quota. So they said that all the institutions where there is a funding that is being taken by the SGPC, that is the Shiromani Gurdwara Prabhakar Committee, such institutions should have a reservation for the Sikh students, and also because they are being controlled by the minority quotas. So that is what the question arising in this case is, and that will be discussed by the court in the further weeks. Now coming to the next case, that is the Janhit Abhiyan versus Union of India. Here they will be testing the validity of the 103 amendment that was introduced provision for reservations to economically weak sections. Right. So EWS has been a very important category that will be discussed here. Now you can see that these all benches will be doing the same. Now Karman Singh Sareen and others versus Union of India and others. This was the case that was the specific leave petition that was filed to closer to the Delhi excessive courtroom judgment in WhatsApp privateness case. Now Karman Singh Sareen and Shreya Sethi has challenged the 2016 privacy insurance of well-appreciated mobile application of WhatsApp, whereas allowing WhatsApp to move ahead with the privacy insurance and to percentage statistics with the Facebook, the excessive courtroom has issued the following commands regarding the same. Now, the next case that we have in our hand today is the Supreme Court to hear a plea on the mechanism to probe sexual harassment complaint against judges. So if there is a sexual harassment complaint against the judge, how would it be dealt? That's what the Supreme Court is trying to make a mechanism for the same. Now the senior advocate Indra Jaisingh, appearing in the matter for the petition, has told the court that she wants some more time for the additional material. So the court has given them the time of 4 weeks to go ahead with the additional material that she wants to file in front of the court. So on Tuesday, the court said it will hear the case on November 15th, the petition seeking the mechanism to probe the complaints of sexual harassment against the judicial officers and sitting and retired judges. Now, the bench was headed by Justice S.K. Kaul, also asked the Secretary General of the Apex Court to place on record his stand on the existing mechanism, followed by the judiciary with regard to the matters. Now, what was happening in the matter was that the court refused to make Bar Council of India as the party to the said proceeding, because a person cannot make the laws which are beneficially or which are against themselves, right? Because they are directly involved in the punishment and the working of that act. So the court has refused that Bar Council of India cannot be a party, and it will not frame rules with respect to the sexual harassment cases that comes against the retired judges and the sitting judges. Now, it is also noted that on the day that there is no mechanism to inquire into the complaints of sexual harassment against all judicial officers, retired judges, whether while holding office or not. Okay, so right now, if anybody lodges a complaint, there is absolutely no mechanism against it, nor there is a redressal committee that will be formed. So that is a problem that was being faced, and that was a maximum lag that you can see in the constitutional matter. So that's why there has to be a proper protocol that needs to be framed regarding such cases. So that's what the court is trying to do here. So these are very, very important cases and very important affairs that are from the month of August and September. So do make sure that you don't forget to hit on the like button, and also don't forget to hit on the bell icon for all the regular updates. Now coming to the provisions. So what are these regular provisions that are being used against the sexual harassment? So Indian Penal Code is the code that provides you with the punishment for sexual harassment. It is defined under section 354 of the Indian Penal Code, and sexual harassment consists of a lot of essentials. So first being a man committing any of the following acts, which includes physical contact and advances involving unwelcomed and explicit sexual overtones. Now, next is a demand or request for sexual favors, showing pornography against the will of a woman, and also making sexually colored remarks. So these all are defined under the Act of Indian Penal Code, and a person can be punished if he commits any act which leads to any of these functionaries that we have just talked about. Okay, so the last case for the day and very, very important news is that a person who avails any banking services under the Consumer Protection Act is covered because he is covered under the definition of a consumer. Now, the name of the case here was Arun Bhatia versus HDFC Bank and others. Now, in this case, along with his father, Arun Bhatia has opened a joint FD account with the bank. Person who avails the banking service falls under the scope of consumers under the Consumer Protection Act and can take recourse to legal remedies provided in the Act. So anybody who's involving in any misleading activities with the consumers, and even if it's a bank, it will be covered under the definition. Right? Now, services of every description will fall within the ambit of the definition of service under the 1986 Act. Right? So, any person who's availing banking services are also being considered as consumers. So, this is it for today, guys. I hope you were able to understand what we are talking about today. These are some of the important affairs. You can read on depth on these affairs also, and also can subscribe to our channel and also visit our Telegram group to read more about these news that we have discussed today. And if you want the entire contextual subject and also the written material for the same news will be available on the channel. So do make sure that you subscribe to our Telegram channel under the name of CLAT@Pratham. So thank you for joining this live session. Hope you all take care of yourself. Have a nice day ahead, and do make sure that you're taking care of yourself in the future also, and all the best for your exams. Thank you, guys.